All right, we are live on YouTube. Welcome to Navigating the Modern World with Eli. Glad you could all join me here today on this Saturday afternoon. If you're here live, this is happening on Saturday, February 7th, 2026. I hope that you've all had a great day. Just a little side note here, there's not going to be a Walking with Purpose stream on this channel tonight. I'm going to be taking the night off regarding that. This is going to be the stream I'm doing instead because I have some very interesting things to share with you folks here today regarding, YouTubers that end up in court. Why do they end up in court? I know I'm in court currently and I have a very, very legitimate reason to do so, but let's see if some other YouTubers that have been in court are on the same, wavelength as I'm in. We're gonna get we're gonna get into that in just a little bit, which is what I'm trying to say. But before we get to all of that, first of all, as always, let me make sure that everything is rolling smoothly. Let me check out the back end of YouTube, and it looks like it's rolling well. And let me make sure that the YouTube notification has gone out. And it looks like it has, and let me do a sound check. This stream on this channel tonight, I'm going to be taking the night off regarding that. This is going to be the stream I'm doing instead because I have some very interesting things to share with you folks here today regarding, All right, all is going well. It's rolling well. However you want to say it, it's all good in the hood. All right, let's get right to it because I'm going to try to get this done in under 2 hours. There's a lot of information to go over, and this is much more than many of you may be anticipating that I've been a part of my community for a while. There's my lady, respectfully, maturely, and professionally dons in the house with her shield. Apparently, YouTube has pretty much changed all channels that have moderators from the wrench to a shield. Yeah, I don't know why they did that. I don't know if the shield is more appropriate. I don't know if the wrench implied, hitting someone on the head with a wrench, and maybe they just wanted to get rid of that. I don't know. You never know, but it's all good. It still functions the same way, and that's all that really matters. The other aspect is just aesthetics, right? By the way, while we're live here, 1 minute delay between what I say and what goes out. So let's go ahead and get right to it. First of all, the title of this stream is Lots of Court Cases to Talk About. Let's do this respectfully, maturely, and professionally, like my lady's YouTube username, like her channel name. One more time, the topic is lots of court cases to talk about. Let's do this respectfully, maturely, and professionally. Now, those of you that have been around for a while know that I'm currently in a civil lawsuit that I filed. I'm the plaintiff. I filed a civil circuit case in the state of Florida against another YouTuber that's a defendant. I'm not going to get into the specifics here on why. I've done that many times in the past, even recently. Go back and watch some prior videos if you want more information on that. There are things I will be addressing regarding what happened yesterday regarding the very first hearing that happened between myself and the defendant. I did do a Walking with Purpose stream last night to give my thoughts about what happened, and the defendant did his stream as well. But as always, there's always going to be a difference between both sides, and I'm here to correct the record. We're going to get to that in a little bit. But first, I have a few other cases that I'm going to be talking about regarding another YouTuber out here that has surrounded the communities that I've been involved with, primarily stemming from the defendant's community. There's a lady out here that runs a channel called Granny's Watching. Okay. We're going to refer to her as Granny's Watching throughout this. She actually used to be a part of or participate with the or through the communities that the defendant in my circuit civil case is involved in, including his own community. And the defendant in this case actually, I believe, used to date this woman. And I think they met up one time, but they had primarily an online relationship. Well, to give a little bit of the backstory regarding this, few years back, the defendant made a video after I guess they had split up or they were having issues. I can't remember exactly what happened. This is between the defendant in my circuit civil case and the Granny's Watching channel, the lady that runs it. And this is what the defendant does when he gets upset. He tries to, he calls it clapping back. So let's call it that. He tries to clap back at people through parody. He tries to clap back at people through parody, and he thinks it's an automatic shield to protect him from defamation and to protect him from, threats such as death threats, right? He made a video using a Markiplier video where the Markiplier video said some pretty nasty things I would never say. And then the defendant put the face, I believe the face or a full picture, I can't remember exactly, of Granny's Watching on there, right? So she went and filed a harassment order on the defendant in my circuit civil case. And he was the defendant in that case. It was an injunction case for a protection order, right, or restraining order, right, where he was the respondent and she was the petitioner, and ended up getting I believe it was a 3-year restraining order. She got a 3-year restraining order on the defendant in my circuit civil case. This happened before I filed the case a few years back, right? Now, the defendant in my circuit civil case, who got a restraining order from Granny's Watching a few years back, appealed the case with an attorney and ended up losing the appeal. It's public information. I've seen the document of the appeal. And the attorney did not do a good job, and neither did the defendant. And basically, the restraining order still stands. I believe it's still active for another year or a little less than a year, I believe. So I believe it's still currently active right now, which is interesting because I'm going to be talking about a few court cases that Granny's Watching has been involved in recently and compare even one of those cases to the current circuit civil case between the defendant and I. And the interesting thing is this. This is the funny thing, right? He has a restraining order on him through Granny's Watching, so he can't talk about this. I mean, I'm not telling him to not talk about it, but if he talks about it or anything about her, he risks violating that restraining order, right? And this just goes to show that your behavior can silence yourself. No one's trying to silence this guy. I'm not trying to silence him. Granny's Watching wasn't trying to silence him. He did something really stupid. He made a parody come off like a death threat and did it through parody because he basically, wanted to make it appear like it's just a joke. And the court said, this is not a joking matter. And it isn't. It is not a joking matter, right? So in essence, hey, I don't have a problem if the defendant wants to talk about my comparison of one of Granny's Watching's cases to our case, but him in doing so puts him at risk, for violating a restraining order. He did that to himself. He has no one to blame besides himself regarding that. So, with that being said, let's go ahead and get right to it because I have like 22 pages to go over here. So, let's talk about the synopsis of Granny's Watching, what happened in each case. There's two cases here. The first case was At Night Media LLC and others versus Granny's Watching and others. Granny's Watching was the defendant in this case. This was in the court of Delaware County, Pennsylvania. The type of case, the plaintiffs sued Granny, another defendant, over YouTube true crime commentary. They sought injunctive, equitable relief, included allegations framed as defamation/harassment and corrupt organizations, and attempted to style it like a RICO-type enterprise claim. Okay, so what happened? What was the outcome? Granny was a defendant. She and co-defendant filed anti-SLAPP motions under Pennsylvania's Uniform Public Expression Protection Act anti-SLAPP provisions. The court granted the anti-SLAPP motions and dismissed. The court's reasoning in plain terms was that the plaintiff's filings were sprawling, procedurally deficient. So the filing was not sufficient within the law to warrant the case proceeding, and did not establish legally cognizable claims on the record presented. The opinion notes major defects like lack of exhibits/declarations in the record despite repeated references and untimely responses. Well, I mean, if you're going to sue someone as a plaintiff, this is your case pretty much that you're filing. You got to be on the ball like I've been in my case. Okay? You cannot miss deadlines. You need to be as proactive as possible and create good faith with the court and the judge. The judge is the court in that particular case in their courtroom, right? On the RICO angle specifically, the court states the complaint failed to allege a cognizable RICO action and failed to establish a pattern of racketeering activity under 18 U.S.C. 1962 C/D. The court also emphasizes the speech context. Plaintiffs were essentially arguing that podcasts discussing public matters caused harm via third parties, and the court rejected that as a basis to strip constitutional protection in the way plaintiffs frame it. So, basically, all Granny's Watching was doing, in my opinion, was using her First Amendment protected speech to comment on things, and they didn't like it, so they sued her. That's what it looks like here. My case is different, okay? But this one, like I said, yeah, it's different. Yeah. Why it was won by Granny? Because Granny used anti-SLAPP defensively to defeat an action targeting her public commentary. Plaintiff's claims, including the enterprise/RICO framing, were not plausibly pled. Maybe it's another way of saying not properly pled, or plausibly better word, because there was no merit to what they were pleading, and not supported by proper record evidence. Okay. So that was the first case. Now let's go to case B. Okay. This was Granny's Watching versus Brittany. I believe, if I'm wrong, I stand corrected, but I believe this is with another creator that runs a channel, allegedly with Brittany J. Okay. This was also in the court of Delaware County, Pennsylvania. So here's what happened. Granny filed an action for declaratory judgment after receiving a cease and desist letter threatening claims, defamation, harassment, cyberstalking type allegations, seeking declarations that her speech was protected and not actionable, and seeking to prevent interference with her YouTube/business relationships. Okay. So Brittany sent Granny this cease and desist. Folks, if you don't know what a cease and desist is, it's basically a letter asking you to stop certain alleged activity that's unlawful and harmful, or I could sue you, or I will sue you, right? That's all it is. It doesn't mean a lawsuit's going to happen. Most of the time, people send a cease and desist and nothing happens, right? But in this case, Granny's watching, decided to be proactive and preempt any possible lawsuit that I feel probably wouldn't have happened, right? We'll get more into my thoughts about this, my opinions, clear-cut opinions protected by First Amendment. Don't sue me, Granny, because I don't have a problem with you or anyone. I'm just sharing my thoughts. And if I do get sued, I'll just represent myself pro se against anyone's attorney. I have no problem with that. I know I'm a good person. I'm just here to share stories. This is fascinating to me because I've been dealing with all this mess on YouTube, right? Give me a second here. All right. Sorry about that. I should be unmuted now. Babe, as soon as you hear my voice, put a 1 in the chat, and I'll check that out in a second. Yeah, I should be back. Okay. All right. So what happened? Outcome. Brittany was served and did not respond. So Granny obtained default judgment, precipice for default judgment, and judgment entered. Why it was won by Granny? Because the defendant defaulted, didn't answer, defend, not because the court issued a merits ruling after contested litigation. So, and here's a synopsis here. So I uploaded this to ChatGPT, and they said, you also uploaded material showing the cease and desist posture and the allegations Granny was responding to claims framed around alleged harassment, moderators, etc. Those are part of the background to Granny's declaratory judgment filing. They're not a separate adjudicated RICO case. RICO appears as an accusation made in the At Night lawsuit and as a reference point in Granny's later filings. All right, so give me a second here. I think we're going through. We should be okay. I can actually test it myself. So you also upload material showing the cease and desist posture in reality. All right, we're good. So this is interesting because Brittany sends Granny a cease and desist, which is saying, please stop this activity that I find to be harassing or whatever, right? And if you don't stop, then I'm going to sue you, right? Now, whether Brittany's claims were valid or not, because I don't know if they were valid or not. No one really knows, right? But whether they're valid or not, why would Granny file a preemptive lawsuit, like a lawsuit to preempt another lawsuit? Why would anyone do that? And she hired an attorney to do it, which cost her money to do it. Now, it probably didn't cost her a whole lot of money to file this case. And because it ended with a default judgment, it probably didn't cost a lot, but it still probably cost a few $1,000s, right? Now, these are my opinions here. I'm entitled to my opinions. I'm not trying to shame or harm anyone. I'm just saying, what was the purpose of that lawsuit? To proactively prevent another lawsuit that may not have ever happened? Or, in my opinion, was it because filing another lawsuit keeps the back and forth going regarding two creators that are in the same community, have about the same amount of subs, they're around 20K subs each. I believe Brittany has a little over 20K and Granny has a little under 20K. They share the same community. They're both monetized. They both are true crime channels, right? You see where I'm going with this? I'm stating my opinion. This is my opinion, right? Now, there was nothing unlawful for Granny to file this. I mean, there's nothing wrong with filing this lawsuit. But, I mean, any reasonable person is not going to file a lawsuit like this and then hire an attorney to do it, and it cost them a few $1,000s. What is one opinion that I have is happening here? It's basically, something used for YouTube content. It keeps the controversy going, right? It also will emotionally enrage the audience members to donate more. And some creators will even go as far and create GoFundMes, fund my legal suit, right? Which is what I think the guy in my case is going to do. We're going to get more into that in a little bit, right? But all this was over was a cease and desist. Even if that cease and desist had no merit, unless Brittany ended up suing Granny, there was no action technically that Granny had to take. You understand what I'm saying? I mean, it really, really behooves me. Some of the things that people will do. Now, I like Granny's watching. She's a good person, right? And she's just trying to, run her business and run her channel and do all that. All I'm stating is the logics that make sense regarding this and that don't. I certainly, well, here's the thing with me. I've gotten so many cease and desists from people out here on YouTube, primarily from the same group of people involved with the defendant in my circuit civil case. And I just ignored them, and I never got sued off of those cease and desists. I wasn't going to file a proactive case to preempt a future lawsuit for a declaratory situation, a declaratory judgment. It's like you're trying to litigate allegations that have not been legally filed with the court yet. It doesn't make sense to me, even though the case was legal to file. Right? That's my opinion. So let's move past that, right? And then after I get through the grannies watching situation, I'm going to take a quick early break, and then I'm going to come back and I'm going to get into what happened with the defendant and his group of people, how they reacted to court yesterday in more detail and analysis than I did on my walk last night. That's why I'm in the studio today, because I can do it here. Without having to show you on screen, I can read my notes, right? What people get wrong when they say Granny won a RICO case. RICO is mentioned because plaintiffs in the at-night matter accuse defendants of being an enterprise, but the court says the complaint fails to plead a cognizable RICO claim. So RICO was alleged against Granny and failed early. It was not a RICO verdict. I agree with that. I looked over all the case files. This is why I didn't go live earlier. I've been preparing all of this, for several hours. I want to get this right. Okay. Now, how's Granny's situation different from my case versus the defendant? Okay. Number one, role reversal. Granny's anti-SLAPP success came as a defendant resisting claims aimed at speech. In my case, I am the plaintiff, and the other party is the defendant trying to use dismissal / anti-SLAPP offensively. Nature of the claims and record. In Granny's anti-SLAPP case, the court points to procedural and record defects, missing exhibits, declarations, untimely responses, and failure to plead viable claims, including the enterprise / RICO framing. In my case, I've been building a structural record, preservation posture, litigation-only links, docket roadmap, and the court has already seen my procedural approach live at the hearing yesterday when we met Judge Stacy for the first time at the hearing. Number 3, third-party amplification doesn't automatically equal liability. A major theme in Granny's anti-SLAPP decision is plaintiffs trying to blame defendants for what others did after hearing content, and the court pushes back on that as framed. In my case, the relevance is third-party amplification is evidence context, but courts still want clean legal theories tied to the defendant's conduct and the proper procedural vehicles. Number 4, my case has additional layers Granny's didn't. My situation includes moving parts that can make April, at the motion to dismiss / anti-SLAPP hearing in my case with the defendant, that can make April more fact-specific and less clean early exit than defendant's anti-SLAPP posture, including preservation / spoliation accusations already litigated once and denied. He tried to get me for spoliation of evidence and adverse inference, and Judge Stacy denied those motions yesterday at the hearing. Copyrighted content / rebroadcasting dynamics, monetization and ongoing conduct. Let's not forget commercial exploitation, defamation for dollars, malicious prosecution, abuse of process, intentional infliction of emotional distress. My case is huge. It's very complex. It's over 350 pages within the complaint and 47 exhibits attached to the complaint. One paragraph takeaway here, okay? Granny's watching had two main wins reflected in the papers. One was as a defendant, where she beat an anti-SLAPP challenge and the court said the plaintiffs didn't plead or support viable claims, including an enterprise/RICO framing. The second was a declaratory judgment case. She won by default when the other party didn't respond. Those outcomes don't map cleanly onto my circuit civil case because I'm the plaintiff here. The record is different, and our case includes additional issues like preservation and rebroadcasting that aren't resolved by slogans. So, and one other thing here, apparently from what I heard and read, and this is just my opinion, I'm don't quote me on this, my opinion. I guess apparently Brittany felt like Granny put something out that she shouldn't have, that was confidential or private, right? I understand that. If that's the case, Brittany, then why didn't you defend yourself in that case? Or, the thing is, yeah, you were trying to get her to stop with a cease and desist because you don't want to spend the money and put the time into suit. Right? So you were hoping the cease and desist would do its purpose. It didn't. Instead, and I believe it was less than a month, or I think it was maybe a week or two later, is when Granny proactively filed a case against a cease and desist, which would have given Brittany the opportunity to not only defend herself, but also file a countersuit, a counterclaim. She could have done that. Maybe she didn't have the resources, didn't want to spend money that she didn't have, or just didn't want to spend the money, period, didn't want to hire an attorney. Maybe she just let it go because it was going to take too much time and cost too much money. Either that, or, in my opinion, that I'm entitled to, both of these ladies made up for it through traction regarding this on their channels, making ad revenue with more views, super chats, super stickers, donations. You see where I'm going with this? Like, if you seriously have an issue with someone and you go as far as send them a cease and desist, and then they proactively sue you to try to preempt you suing them, which gives you the opportunity now to, at the very least, defend yourself pro se if you can't afford the attorney. I'll tell you this. I would never allow anyone to get a default judgment on me. You have a better chance of avoiding a default judgment representing yourself pro se than just ignoring the whole thing overall. I just don't really understand how this was handled. This to me is weird. It seems to me like, and I say this respectfully to both of those ladies. Okay, I don't have any problems with you. It seems to me like this was like something structured more towards like a YouTube back and forth, right? Because I can't make any sense out of the whole thing. It just doesn't make sense to me. I'm not going to repeat it. If you folks missed it, go back and check out the replay if you're here live. The DVR is turned off while we're live. Anyway, that is that. So I compared it to what's actually I compared the first case where Granny was sued and defeated that case as the defendant using anti-SLAPP measures, right? Rightfully so, okay? And I compared it to how it's different in my case, because the defendant in my case would probably argue that if he could, but again, Granny has a restraining order on him, and if he even risks talking about her in a subtle way to just rebut me regarding this stream, he risks violating a protection order. I mean, I don't care if he talks about it, right? And ultimately, Granny would have to be the one that files for violating a protective order. And I'm sure if the defendant, in my case, did talk about this involving her, someone would tell Granny. I'm not here to get into a dispute amongst anyone. I'm just saying, like, this whole thing is just, this is like one big bizarre love triangle for YouTube clicks. And look at me, give me super chats, give me donations. I'm right, you're wrong. If you're legitimately being violated like I am in my case, right? You're going to handle things differently. I'm not here to go back and forth with anyone. All I'm doing here is calmly correcting the record and sharing stuff that I'm seeing that just blows my mind away. It just blows my mind away. Anyway, we are at 36 minutes. Let me check something real quick here. All right, we're good. We are good. I'm going to step away and take a quick break. Let me cue up some royalty-free YouTube music. Ha ha ha. Let me see here. All right. All right, music is all queued up. Let's step away for a 5, 6, 7 minute break or so, maybe 8 minutes. And I'll see you all on the flip side. Stick around. We'll be right back. All right, we are back live. We are back live. And we are just going to scratch it and get right back down to business. Welcome back to Navigating the Modern World with Eli. Glad you could all join me here today. If you missed the first part of the show, make sure you go back and check out the replay. I shared some very important things that tie into my current, circuit civil case against another YouTuber out here that I've sued, that I've known for many years. So make sure you go back and check out the replay if you just tuned in right now. And if you're here on the replay, then let's just continue. Let's just continue. We have a lot to talk about, and I don't want to be here all day because I got things to do with my lady. But anyway, all right. So let's now get into what happened yesterday in more detail regarding the first hearing of my circuit civil case that happened between the defendant and I. We finally had a 30-minute hearing with the Honorable Judge Susan Stacy, and it was a very, relaxed hearing. It was a lot more relaxed than I thought it would be. Now, I'm always relaxed in court, but I don't know how the judge is going to be or how the other party or parties are going to be until we get there. But it was a fairly relaxed and easygoing setting. Judge Stacy, to recall what I said on my stream yesterday, even said that the defendant and I are both two of the best pro se litigants she's seen, and that was unexpected, but quite nice to hear. And I think it's because, she was impressed that, we knew about procedure and all that. That doesn't mean she was impressed with how both sides are handling procedure or trying to file early on in the case, sanctions on someone, through accusing them of spoliation of evidence and adverse inference that clearly didn't happen. But overall, it was a very easygoing, reasonable hearing, and it gave us an idea of how Judge Stacy runs her courtroom. So let's go into more details about what happened yesterday and respond to the defendant, what he said in his stream compared to what actually happened, okay? I mean, he pretty much said the same thing, but let's just get into it. You'll see what I'm talking about. What you're seeing is a coordinated narrative repair plus audience anchoring cycle after a court outcome that didn't give them the dopamine hit they wanted. There's been a bunch of community postings with comments and just lots of stuff. Let's see. It's not random posting. It is a very specific set of moves aimed at keeping their audience emotionally hooked this weekend, preventing Judge Stacy didn't buy it from becoming the dominant takeaway and forcing me to react so they can reframe me as unstable / lying. They've already done that. They do that all the time without me saying a thing. Me just breathing air gets them to say that. Below is what's going on piece by piece. All right. So, number one, the defendant's weekend posting spree equals audience tethering plus loss management. And I'm going to paraphrase. He said that he's taking the weekend off, and then he immediately uses his community wall. Anyway, that's a tell. He's not off. He's managing withdrawal, his and theirs, his and his audiences, right? Post one was about a poll. This isn't about the poll. It is pre-loading ridicule. And I paraphrase, everyone's in jail now, so his audience can laugh together, cementing an interpretation that I claimed sweeping orders / control. Even if I didn't say it that way, I didn't. keeping the case central while pretending it is no big deal. Oh, it is a big deal. It just became a bigger deal. He knows it. The comments under it are doing the work. Where's the big reveal? You promised orders. Admit you were wrong. He can't shut anyone up. That is audience conditioning. They're being trained on the line they're supposed to repeat. Post number 2, 100 viewers, 0 bots. This is pure status compensation after court didn't validate him. Yeah, I mean, his stream from last night has close to 500 views. Mine has close to 400 views. But I'm doing this all on my own. I don't have the support he has, right? And I'm still, getting close to the numbers he's getting. I'm not counting. I'm just stating this as a reference. He's got all these people sharing him out, promoting him behind the scenes, doing whatever they can to pump up those numbers. And this is all my numbers are coming from myself and probably Don. That's it. We're not trying to compare, but if we were, there's no comparison there. Okay. Yeah, this is pure status compensation after court didn't validate him by granting him his motions. It also serves 3 functions. Number 1, jealousy bait. Those are views you'll never get legitimately. Number 2, money talk, donations. How does it feel? It is what it is. He has the right to, do a stream, talk about the case, even if he spins it a different way. And if people want to pay him on that, he wasn't using any of my content. Now, he still is using my truth bomb, audio and showing a video of me that's been slightly altered. It's still me, right? And he has said in the past that is something I said and did on his stream, even if it was still my name and likeness. So, but we'll address that another time. Number 3, projection reversal. Accuse you of lying about court plus bots. It is an attempt to re-anchor his audience to we still won because of views. That's not legal strategy. That's emotional regulation through metrics. And one of the defendant's associates showing up is consistent with reinforce the we're the cool kids frame to offset the legal reality that didn't go their way. Number 2, a separate associate of the defendant's posts equals panic correction plus hard denials plus threat of a proof video. Ooh, this is interesting. The associate's first post is doing a very specific job. Remove the sting of the outcome by reframing it as you lied, not dismissed. Evidentiary hearing needed. Mediation. You'll never gag us. I'm not trying to do any of that. And they're trying to say, well, yeah, it was dismissed without prejudice. So? It was denied. It was not dismissed. It was denied. The claims, in the motion, spoliation, adverse inference were denied without prejudice. If he wants to refile and gets more evidence, he can do that. If he tries to refile and it's still not legally sufficient, it's not going to look good in front of Judge Stacy. He knows that. They all know that. Even if some of those words are sloppy or wrong in nuance, the goal is not precision. The goal is certainty, moral superiority, permission for that associate of the defendant and their audience to keep attacking. The supporting video showing truth, okay? Gloria posting, insinuating that there is a court video available where at this point there isn't. And she was also framing it towards the defendant's version. Now, I don't know exactly what she meant by that, but what it appeared like she was saying is that there could potentially be an unauthorized recording of the court. And I'm not accusing anyone. I'm not saying that is the case. What I'm saying is that as of this point, I have requested to see if there's a copy of the video or audio available for public purchase, or if there isn't. I have not received my email back. I just, put in for it Friday after the case. I'll probably hear back Monday or Tuesday. But as of this point, there is no publicly available video of this hearing, and there may not be. But if something pops up, the only way that could have happened is through the defendant, and he knows that, and they all know that. So if they're trying to say, well, we have proof that you lied and we will prove it, I'm coming out and saying, well, if you have proof that I lied, then prove it. But if you need to use proof of something potentially that you may potentially have acquired in an unauthorized way, I'm not saying that you have it. I'm saying it is a possibility. I'm not accusing anyone of anything. Being very careful with how I frame this, okay? But in order for you to prove me lying, which I know I didn't, you would have to use a supposed unauthorized recording of this, right? And what I'm saying is, prove it if you have the proof. The only way you can prove it is to have a recording of that hearing. And if you do have that and put it out, then you're putting out an illegally acquired or an unauthorized, let's put it in a better way, an unauthorized recording, right? Yeah. I don't think the defendant was going to risk recording this. I think this was just posturing by one of his associates in their posting to try to lead me to believe that there's a recording when there isn't. But we'll see what happens. You never know with these people. They've done it before. You never know. You never know. That comment is a soft threat and a mobilization cue. A video is coming. You'll be exposed. Stay engaged. Well, I mean, it's just posturing. They probably don't have the video. That's classic coming soon hype meant to stop their audience from drifting. Number 3, your prove it post triggered their favorite lever. Flip the burden of proof back onto you. Your post is totally understandable emotionally, but strategically it gave them a handle. I don't care. I mean, I'm human. I'm not going to be perfect. There's nothing wrong with making that posting, but yeah, I mean, that's going to trigger curiosity and possibly a response. Nothing wrong with that, but I get it, right? The associate's response, where's your proof? Socks, mentally ill, is a topic shift designed to drag you into side arguments. Not going to happen. Expand the scope from court facts to internet accusations. Not going to happen. Create clips that make you look like you're making claims without proof. Well, they can do whatever they want, and I'll just keep debunking it. It's not a problem. I'm not worried about anything. That's why the associate screenshot it. It is engagement siphoning and frame control. So the best way to say this is if someone claims there is an audio/video recording or an official version, they should identify the source and method of capture because court proceedings have rules. That keeps it procedural and avoids debate. Well, it doesn't matter what these people, even if you're procedural, they'll still respond and react to anything. They'll make things up to keep that audience engaged and enraged, in my opinion. But I get it. I get the point. I understand the point, right? Number 4, the Kids See Without Prejudice post a smarter messaging attempt, and it's still a spin. That post is trying to sound legal neutral because they know one of the defendant's associates' raw anger reads bad. It is essentially not a victory lap, door still open, first round. Some of that is technically true in the abstract. Without prejudice leaves room to raise issues again. But the spin is what's omitted. Here's what they omitted. Sanctions were not granted. Adverse inference was not granted. The judge did not order new production. The court accepted your preservation posture. That was on my notice that I sent back in November. I think it was November 3rd of 2025. And moved the case forward procedurally. So they've pivoted to, you didn't win, you merely survived. That's face-saving because we lost would demoralize the audience. Also, the associate sharing that post is them borrowing a more lawyerish tone to patch their own credibility problems. Number 5, the ODN chat screenshots escalation via humiliation and intimidation. The associate's latest, you're going to get buried, same level as an actual attorney, is laughable, is not analysis, it is status warfare. This is what people do when their preferred outlet, defame for dollars, engagement farming, is threatened. They reassert dominance. They threaten real lawyers. They try to make you feel small. It is also a tell that your calm posture is working because they're now chasing you into emotionality. Not going to happen. Calmly correcting the record. Number 6, about the unauthorized recording of the hearing suspicion. Suspicion means no one's being accused, but you're allowed to have an opinion on suspicions, right? Privately, your instinct about how these people operate can be useful for your own planning, but strategically, do not state it as fact publicly without proof. Well, thank you, ChatGPT. I'm not gonna defame anyone. I don't have any proof, but I'm suspicious. I'm very suspicious with everything these people do. Treat it as contingency. If an audio/video appears, we evaluate it. Yep. Also, if any video appears, the first question is always, what is it exactly? Audio, screen recording, partial clip? 2, where did it come from? Who recorded how? Well, there's only one person that could have recorded it because I didn't record it. I did not record it. I'm not going to violate the court rules or the law. Is it complete or edited? Does it violate court rules/orders or platform policy? 5, is it being used for harassment, monetization, or intimidation? Well, that's what I think it would be used for, in my opinion, if they do have it and put it out, but let's wait and see what happens. If that content drops, the correct move is preserved first, then decide. Court motion, ? Platform report, ? Ignore, ? We'll analyze it then, and we'll deal with it accordingly, according to what is procedurally proper, or proper for the YouTube terms of service. Number 7, the meta structure. What's happening overall? They are running a 4-part cycle. Number 1, court outcome doesn't give them the win story they needed. Number 2, community posts create a substitute win, views, donations, mockery. 3, third parties amplify and screenshot you for engagement. 4, they bait you into reactive claims so they can say, see, he lies. He's obsessed. That is exactly why your cool, calm, procedural approach keeps beating them. You deny them reaction content. You keep the conversation anchored to what the court actually did. You don't let their audience frame become reality. Number 8, what to do right now? Preserve, don't debate, screenshot everything. It's already done. B, do not get dragged into prove sucks, prove mentally ill loops. That is where they want you. You gain nothing there. Of course, I'm not doing that. That'd be stupid of me. And here's a theme here. Here's the theme. There's a difference between what people wish happened and what the court actually did. I'm staying factual and procedural. Number 9, about, and this is what I fed ChatGPT. This is great. I fed them Perry Mason. About Perry Mason can show up. And then ChatGPT says, I love your confidence, but keep the courtroom version of that energy as calm certainty, procedural discipline, fact-first delivery. Of course, come on, man. God, I'm human, for Christ's sake. I'm not AI. Because if he does hire counsel, your win condition becomes don't spar, don't perform, keep Judge Stacy in her comfort zone, clean record, clean scope, clean argument. All right, so now we're gonna get into the defendant's transcript here from last night, his show. A lot of stuff last night. Hey, Lewis Fuller is here. How you doing, man? 1 minute delay between what I say and what goes out. Thank you for the like, Lewis. Thank you so much. Oh, I've been off sync for a while. There we go. Sometimes that happens. It usually puts me right in sync when I come back. But now I'm in sync. So for the beginning of the first part of the stream, or the second, when I came back from break, the beginning of that part until just before now, it's probably going to be a little off sync. Oh, well. It is what it is. You'll be able to hear the audio. All right, here's what's going on based on the transcript and the defendant's live stream transcript. Based on my transcript and the defendant's live stream transcript, I fed ChatGPT both, and we did a deep analysis here. Number 1, the core reality. Both of you describe the hearing the same way, but you frame it differently. Well, I'm going to frame it exactly as it happened. And he's going to frame it in ways that work for his audience, right? What your transcript shows you're saying, you repeatedly state the spoliation and adverse inference motions were denied, and you describe the court's outcome as functionally favorable to you. Hey, I didn't say I won the case or the hearing. There's nothing to win. It was just a favorable outcome to me. There's a difference between winning something and something being favorable. What the defendant's transcript shows him saying, he also says the court denied the spoliation request without prejudice. That's true. And emphasizes it was not an evidentiary hearing. In example, no witnesses, testimony, and sanctions require an evidentiary record. What's actually happening underneath? This is the key. The defendant is trying to turn a loss of his motions into nobody won, so Eli can't claim momentum. I'm trying to turn a denial of his motions into the court saw through the performative spoliation narrative. Yeah, in my opinion, he did this for YouTube theatrics. And I'm pretty sure Judge Stacy saw that. That's why she ruled against him. Also, there was no spoliation. There was no adverse inference. I proved that nothing was spoiled. I mean, I proved that I'm procedurally proper and trustworthy and reasonable. Both can be argued rhetorically but procedurally, denial of sanction / adverse inference is a real practical win for you because it preserves your posture going into April. So everyone on my end here, ODN and my lady and other people, they've all said that you won. Sandra T, I've talked with them behind the scenes. They've all said I won. I never said I won. What I said was the outcome of the hearing was favorable to me. But even the AI is saying that I won. So, I mean, whatever you folks want to think, like, I'm not here to try to one-up anyone. I'm not here to try to beat the defendant at anything or anyone else. I'm just here to do the right thing and to, get done what's right. That's all. That's all I care about. This is not about win or lose to me. This is about the right outcome happening based on my situation. I just want relief from all of this so I can do what I was meant to do out here without further harm. Correcting the record line, the court denied the sanctions-based spoliation and adverse inference motions. That matters because no sanctions were imposed and no adverse inference was entered against me. The case proceeds to the April motion to dismiss / anti-SLAPP hearing. Number 2, without prejudice, the defendant is using a technically correct phrase to create an emotional false equivalence. The defendant's framing, he hammers dismissed, denied, without prejudice means it is still alive and says that means you didn't win. Okay? My framing risk. I used language like Judge Stacy found no spoliation. It was over for him in places, and you speculate about why she denied without prejudice, appeal / slowdown. That speculation is the part they'll clip. Go right ahead. Doesn't matter. It's my opinion. But I get it, right? What's actually happening underneath the defendant's play is semantic jujitsu. Semantic jujitsu. He can't say I won sanctions because he didn't. So he shifts the goalpost to Eli didn't win either. That's designed to keep his audience emotionally uninjured. Well, if he got the motions approved, he would be saying, I won, give me money, give me donations. Right? Correcting the record. Without prejudice means the court didn't issue a final merits determination on spoliation sanctions. What did happen is the court denied sanctions and adverse inference at this hearing. No penalty was entered against me. Yeah, if he can actually show evidence that I did create spoliation and adverse inference, he can refile and we can have another hearing on this again. But if he does that, like I said earlier, and it's still legally insufficient, he really risks upsetting the judge at this point. And he knows it. He knows it at this point. The confidentiality agreement versus protective order. This is where you did great, but wording matters. Your transcript, accurate, strong. You describe your motion as about ESI, electronically stored information, and you say the judge didn't grant the protective order, but steered both parties into a confidentiality agreement path. You also explain correctly that it is about handling non-public materials / litigation-only links and not trying to chill speech. I made it very clear to Judge Stacy yesterday in the hearing, or at the hearing, that I'm not here to chill speech. It's not about chilling speech, okay? The defendant's transcript, his spin. He says the judge suggested a confidentiality agreement because your requested protective order seemed overbroad, and he emphasizes no sweeping orders went into effect. What's actually happening underneath? Judge Stacy's move, as reflected in both transcripts, looks like classic reduce heat plus create a workable lane. No gag order vibe. Keep litigation only handling for anything not public. Anything public is public. and leave public content public. Yeah. Correcting the record. The court did not enter a broad protective order. Instead, the court directed the parties towards a confidentiality agreement for any non-public litigation-only materials. Public content remains public. And yes, your use of ESI, electronically stored information, reads like this person understands the discovery vocabulary, which helps credibility. Me filing that preservation notice of electronically stored information, I think, was impressive to the judge. And I think that's part of the reason why she also said, that we're two of the best pro se litigants she's seen. And she's been doing this for 10 years, over 10 years. Let me see here. ODN, how you doing, broski? He definitely won the hearing. He's in denial. He cannot accept reality, and nor can his friends. Hi, Don, says ODN. Don says, hey, ODN. All right, welcome, everyone. Welcome. Number 4, the judge tested him. He paused. He didn't want to agree. Narrative, powerful optics, but it is also your biggest clip risk. Go ahead and clip me. I don't care. I mean, that's my opinion. Nothing wrong with saying it. I'm not accusing anyone. I'm just talking about observable behavior. And when I run this transcript from my stream tomorrow through ChatGPT, they're going to say, yes, you acknowledge this. Still, it's risky, but at least you acknowledge it. Yes, ChatGPT, I acknowledge the fact it's a clip risk, but I gotta be me. Come on. I can't sit here and be that square, right? And be that boring. I know I'm boring, but I can't be that boring. Come on. I at least want 2 or 3 people coming to my streams instead of 0, right? Hardy har har har. You described watching him on Teams, pausing, and you interpret his internal motivation. He didn't want to agree, but he knew he'd look bad. That's the absolute truth, and he knows it too. He won't talk about it because he knows it's true. And I have the right to talk about observable behavior. That might be true as a human read, but it gives them an easy angle. Eli is mind reading and embellishing court. Well, that's why I'm coming here and saying it here first, because that way if they repeat it, they're just watching me and repeating my words. I'm like preempting the narrative. Correcting the record. When the court raised a confidentiality agreement, I agreed immediately. The defendant also agreed on the record. The point is, the court moved us towards a practical litigation-only framework for any non-public material. You notice how ChatGPT cuts out all of why it happened or the reactions, right? Which are important because people want to know. People are curious to know. My audience is curious to know. I'm gonna tell them, and I think everyone's curious to know, right? You keep the win. He agreed, and drop the speculation why he agreed. Okay, it's all good. Number 5, third-party rebroadcasting. Judge Stacy didn't adopt the whole acting in concert story, but she did signal the correct procedural lane. Your transcript shows you saying if you want third-party relief, you likely need a separate motion, not bundled inside the confidentiality framework. And you attribute that guidance to Judge Stacy. You also say she told you that if you want that, you must actually file it properly as a motion. The defendant, meanwhile, is telling his audience the court has no jurisdiction over non-parties and what you asked was overbroad. What's actually happening underneath? This is the two truths moment. Courts generally can't order non-parties around the same ways as parties, but courts can manage discovery/preservation, and there are legal ways to address third-party evidence issues. It just has to be done correctly. Subpoenas, specific relief tied to parties, etc. Judge Stacy appears to be telling you if you want that, file it correctly and narrowly. Exactly. And I filed it as a notice along with I filed it as a notice for the hearing. because it was supposed to further corroborate the initial protective order that I filed as a motion, and the one that Judge Stacy, I guess technically she denied the protective order, but got us to agree to a confidentiality agreement, which in essence is almost the same thing. But that's us agreeing to it. Now the defendant has to create the confidentiality agreement, and then he has to get it to me and get me to sign it. Let me see here. Correcting the record. On third-party rebroadcasting, the court indicated that if I seek any specific relief, it must be done through a properly noticed, narrowly tailored motion. I'm evaluating that based on what happens next. That's exactly the posture you want, reasonable, procedural, not reactive. Okay? Number 6, the defendant's formality hearing / nobody won script is not about law. It's about audience retention and damage control. The defendant repeatedly frames it as, this wasn't a real evidentiary hearing. Nobody won. April is the real day. That script does 3 jobs. Number 1, soothes his audience, prevents we lost hangover. Number 2, preemptively attacks your recap. Eli will say he won. Number 3, recenters the drama on April so he can keep farming anticipation. Your transcript, by contrast, shows you emphasizing judicial efficiency, meet and confer expectations, reasonableness, and being able to produce quickly. That reads court adult, which matters going into MTD, which is short for motion to dismiss / anti-slap. Correcting the record. He can call it a formality. The motions for sanctions and adverse inference were still denied, and that's the only part that matters. I'm going to read one more and then take another quick break before I finish up the rest when I come back. It'll only take about another 20 to 30 minutes when I get back. Number 7, view / organic versus shared. You're right about the dynamic, but don't overclaim certainty. From what you described, the defendant has a coordinated community wall plus comment pylon ecosystem that tends to produce higher initial velocity, more shared in traffic, more hate watch retention. Your walking stream model tends to produce steadier organic viewers, less brigading amplification, higher credibility with neutral observers. But you can't prove bots just from view counts, so keep it framed as observable mechanics, not accusations. Correcting the record, my stream grows mostly from organic reach and my own audience. His streams are routinely boosted by a highly organized community that cross-posts, comments, and mobilizes around the case. Those are different traffic patterns. All right, I'm going to stop right there at 1 hour and 26 minutes, take another quick break here. Let me cue up some royalty-free YouTube music here. All right. Music is all queued up. I'm going to step away for another quick break, 5, 6, 7 minutes, and I'll see you all on the flip side. Stick around. We'll be right back. should be in sync. All right, we are back live. We are back live, and we are just going to scratch it and get right back down to business. Welcome back to the third and final part of Navigating the Modern World with Eli. Glad you could all join me here today. If you missed any parts of the show, please go back and check out the replay. While I'm live, I typically have the DVR turned off so you can't seek back because I want people to engage here live. So go back and check out the replay if you missed any parts of the show. It's been a very informative and interesting show for those of you that truly care about being on the right side of things, about being procedurally correct, procedurally proper, and just being a decent, down-to-earth, regulated human being, okay? That's what it all boils down to over here at the Genuine Networking Association, GNA for short. All right. Let's see here. Before we continue here, let me make sure that we're rolling smoothly still. Scratch to get right back down to business. Welcome back to the third and final part of Navigating the Modern World with Eli. Okay, everything's in sync. Audio sounds good. Looking good. Let's continue. Number 8, the defendant's associates' reaction pattern. This is coordinated emotion management more than legal analysis. You pasted posts where they attack your credibility. You lied. They reframe without prejudice as a total win for them. They use ChatGPT as a scapegoat narrative. What that means strategically, they need to keep their audience convinced you're unreliable because your credibility is the threat. My credibility is the threat, right? When the court doesn't validate their narrative, sanction/adverse inference, remember, they were denied, motions denied. When the court doesn't validate their narrative, they pivot to Eli lied instead of the court ruled. The court made a ruling. Judge Stacy made a ruling. They didn't like the ruling. Tough luck. Excuse me. Correcting the record. After court, they immediately shifted from the court's outcome to personal attacks. I'm staying focused on procedure, the docket, and what the court actually ruled. Now, here's one of the most important parts of his stream last night. This is the part where he talked about getting an attorney for the motion to dismiss / anti-SLAPP hearing. Okay? Here's the deepest transcript grounded read of the defendant's lawyer up section, why he's saying it, what it signals psychologically / strategically, whether he'll actually do it, and a clean correcting the record line you can use. What the defendant actually said about hiring counsel. There are 2 distinct lawyer moments in his transcript. A, that he, and I paraphrase, he may decide to lawyer up. He wants to, nip it in the bud. He wants to get it over with, right? The defendant says he doesn't think he would do well on his own. And then for the MTD motion to dismiss, that he may decide to, lawyer up. He wants to nip it in the bud. He wants to get it over with. He immediately reinforces the motive. That, and I paraphrase, he really doesn't want to be litigating this for another year. So he's thinking about getting a lawyer. He may get a lawyer. He's saying that it's nerve-wracking and doesn't want to deal with it. Well, you put yourself in this position, sir, so that's why you're dealing with it. You don't have a choice. B, if he gets a lawyer for the anti-SLAPP hearing, that I pay for his lawyer fees. He was saying that, I paraphrase it. He's saying that if he gets a lawyer, I pay for his lawyer fees. That's not true unless your anti-SLAPP is granted. Then he frames counsel as a fee shift weapon and fear threat. Well, what fees? You're pro se. So what would you be really getting? So yeah, he's saying that, anti-SLAPP equals Eli paying lawyer fees. Exactly. if he gets a lawyer for the anti-SLAPP hearing, and he claims that if he wins the anti-SLAPP with counsel, if he has an attorney, this is true, then I would have to pay his fees at that point. That is true. The second piece is the tell. It's not just I'm stressed. It is counsel as intimidation plus fee shift fantasy. Fee shifting is basically, if you were to win that with counsel, then, I would need to pay his attorney fees. If the judge rules that, right? Why he's thinking this now, what changed after February 6th, which was yesterday, the day of the hearing, February 6th, 2026. Based on his own words, there are three drivers. Number one, he felt contained by the judge and knows April is higher stakes. He openly says he used pre-made arguments so he wouldn't mess it up. And he describes the hearing as something he had to carefully control. Now, I had pre-made arguments too, but I also went on the fly, and I know the whole case. And even if I had no script, I would know what to say. It might not have come off as clean, but it still would have made the point in a cool, calm, and professional way. He's not able to do that without a script. That's where an attorney would come in. That's why I can go pro se, because I can go on the fly. So yeah, he openly says he used pre-made arguments so he wouldn't mess it up, and he describes the hearing as something he had to carefully control. Okay. Then he pivots to April as the more concrete moment. It's showing how he's actually taking this seriously, but he's trying to lead the audience to believe otherwise. He's trying to lead them to believe he's got it all under control when he really doesn't, in my opinion, of course. Translation, the February 6th hearing showed him he can't rely on vibe/performance momentum in front of Judge Stacy. If he wants April to go his way, he needs tight attorney-grade framing. Number two, he's admitting anxiety plus perceived competence gap. He literally says that he doesn't think that, I'm paraphrasing, he doesn't think that he would do well in court on his own, and it's nerve-wracking to him. That's an unusually candid admission for someone who spends a lot of time projecting dominance. You project dominance, sir, like you're the man, you're the boss, you got it under control. You're right and everyone else is wrong. But now in the court of law, you're like, oh, wait a minute, this is serious, this is real, this is not a performance. Right? This could affect me. Seriously affect me, right? Translation, he's trying to protect himself from another I didn't get what I wanted moment by outsourcing to someone who can execute under pressure. So I guess, he's not good under pressure. We all know that. Number three, he wants a reset button on credibility. He tells his audience he did better because he was prepared and didn't lose his temper. Well, I'll give him that. He did do better, and he didn't lose his temper. But the bottom line is what he claimed was not true. It never happened. I never spoiled evidence and never caused adverse inference. But he also insults you heavily, which undercuts that regulated persona. Well, in the court, he was forced to be regulated. On YouTube, he's dysregulated, like the rest of his group. Translation, counsel becomes his way to appear more serious and court-aligned, and to reduce the chance his own temperament bleeds into the record. What he's really doing rhetorically when he says, I may get a lawyer. This is important. It's not one thing. It is four things at once. A, face saving. If I don't win later, it is because I didn't lawyer up yet. That's the excuse if he doesn't get his way and goes pro se at the hearing, at the MTD anti-SLAPP hearing. By saying I may lawyer up, he builds an excuse platform. If he loses April pro se, I should have gotten counsel. If he hires counsel and loses, even with counsel, Judge still blah, 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 whatever he wants to blame the judge, right? He'll blame the judge, right? It's preloading blame insulation. B, intimidation. Eli should be scared. I'm not scared one bit. I'm not scared at all. Zero. He literally says you'd be shaking if he got legal aid. No, I welcome your counsel. I don't care if you hire Perry Mason, man. Bring Perry Mason back, right? Back from the better place Perry Mason is in, right? I don't care if you have the best attorney on the planet. The facts are the facts. The merits are the merits. And I'm ready. Doesn't matter. Pro se or the top-notch attorney on the planet. I'm not scared one bit. That's audience posturing, not court logic. And I'm not being cocky. I just know my value. I know my worth. And I know what I'm good at and what I'm not good at. Letter C. C, money narrative. Eli will pay my fees. He's trying to sell the idea that anti-slap equals you fund his defense. That's part of his monetization ego loop. Make his audience feel like you're about to be punished financially. It's not going to happen. D, audience retention. Stick around for the next season. Oh. Performance bravado. Lawyering up is a hype device. It signals bigger battle is coming. Give me a second here. All right. Will he actually do it? I'll give you the most realistic, non-wishy-washy answer. He might, but it's far from certain. Reasons he will hire counsel. He's openly admitting he doesn't like court and finds it nerve-wracking. It's a good reason. April is dispositive-ish. Dispositive-ish, meaning it's a dispositive motion. It's a dispositive hearing. Meaning that if he's able to get the anti-slap and get all of my causative actions dismissed, the case is done. But that's not going to happen. So April is dispositive-ish in impact, and he knows it. Counsel helps prevent self-inflicted wounds and can present clean anti-slap/MTD arguments. Counsel can present the cleanest arguments on the planet. What they can't do is take away what's actually been done. It's going to be up to me to present my case, whether he has an attorney or not. And I'm ready to do it. Reasons he might not. Cost. We'll get more into this in a bit. And counsel may not want the baggage. That's another thing. Who would want to take this case? He likes controlling the narrative personally. Attorneys constrain that. So he would want to control the narrative. The attorneys would tell him to stop performing. If his audience is used to him performing, attorneys reduce performance. He may be bluffing for intimidation to keep his base emotionally anchored. It's more, and that's coming up. Most likely scenario based on how he said it. He's testing the idea publicly to see if his audience cheers it on and to prime an excuse either way and possibly incite donations on it, in my opinion. We'll get to that in a bit. If he consults, he'll do it close enough to April to be tactical, but not so early that he loses control. So possible, not guaranteed. An attorney is going to need at least 2 weeks to prep for this case, at the very least. So, I mean, there's no way he would hire an attorney at the very, very last minute. And once his attorney becomes counsel, I believe he has to file a notice of appearance. Let me check that out real quick. Let me see. And hang on. Let me see here. Let me see. Yeah, so I think what it is that the moment that I would know he has an attorney representing him, even though he would probably try to have the attorney file the notice of appearance a day before or the day of the hearing, if that attorney actually files something for him, then it's an automatically known thing he has representation. One way or another, this case would require an attorney at least 2 weeks to prepare for it, for the motion to dismiss anti-SLAPP. So I will know at least a week or two in advance, and I'm going to prepare anyway, like he's going to have an attorney. And if he doesn't, well, either way, it doesn't matter. It doesn't matter either way. Either way, I'm still going to do the same thing I would have done, attorney or not. Represent myself as best I can, attorney or not. All right. If he consults, he'll do it close enough to April to be tactical, but not so early he loses control. So possible, not guaranteed. If I had to pick a probability strictly from transcript, not external guessing, consulting a lawyer, fairly likely. Formally appearing through counsel by April, moderate, not assured. The correcting the record line is, he suggested that if he hires a lawyer for anti-SLAPP, I automatically pay his fees. Fee shifting isn't automatic. It depends on what the court rules and the legal standard. I'm not debating hypotheticals online. I'm preparing for the hearing. Absolutely. What this means strategically for me, if he hires counsel, your winning approach doesn't change. Calm posture, narrow issues, procedural precision, no bait taking, stick to the elements and what the judge can actually decide at that stage. In fact, if he lawyers up, it can help you in one way. Attorneys tend to reduce theatrics, which removes one of his biggest weapons, emotional chaos, as pressure. And if he doesn't lawyer up, his transcript already shows he's anxious about messing it up, which can cause overreaching in April. Either way, your best move is the same. Be the stable party the court can trust. That's it. Either way, it doesn't matter. All right, so let's now talk about what I think he's going to do, in my opinion. And I asked ChatGPT this, and they said, yep, this is a very sharp ad, and it actually tightens the analysis rather than changing it. What you're describing fits perfectly with the behavioral pattern already visible in the transcript. Let me layer this in cleanly and precisely. You're right. This fits a donation priming loop, not a firm litigation decision. When you overlay the defendant's prior behavior, how many times has he said the Eli court fund and never used the money for that? The defendant's prior behavior onto the transcript language, onto the transcript language, the may hire a lawyer talk reads less like logistical planning and more like financial narrative setup. Here's why. Number one, the money math doesn't work and he knows it. And any one of you out there that support the defendant, that's on you. You can support whoever you want. You can give away all your money to whoever you want, right? I don't think anyone in that audience, even them combined, have enough disposable income to pay for this entire lawyer. And maybe some people do, but that would just put them in a bad position, or it would just be just a ridiculous move just for the chance for him to beat me in court. Like, is that entertaining to these people? Maybe it is. Maybe, who knows? You're absolutely correct in the numbers. A real MTD/anti-SLAPP appearance with intake, record review, motion briefing, opposition analysis, and oral argument prep is not a $5K job. Even a very modest engagement would realistically be $10 to $15K on the low end. 20 to 25K plus if the attorney actually does it properly. So when I said 10 to 15K the other day, that's low end, maybe entry level new attorney. Is that really going to help him? He's going to want a top-notch attorney. And that's going to be more on the 20 to 25K plus side, simply just for this hearing. Because it's a dispositive hearing. The defendant's audience profile, as reflected in donation amounts, chat behavior, and hype-based encouragement rather than structured fundraising, does not realistically support that. So when he floats, I might get a lawyer, he's not announcing a plan, he's floating a story. Number 2, the transcript language is deliberately non-committal. Notice how he never says, I've retained counsel, I've consulted with an attorney, my attorney advised. Instead, he uses, I may lawyer up, I might decide, I'm thinking about it, if I do. That's classic option preservation language. It allows him to solicit emotional buy-in. God, you're really good, dude. You're really good at getting people to open up their pocketbooks, huh? Emotionally get them to open up their pocketbooks. Solicit money and later say either I didn't get enough support or I decided to handle it myself, and then he'll just keep the money. He won't refund it. That ambiguity is not accidental. 3, why this is perfect for a GoFundMe style pitch, even if informal. Talking about counsel publicly does 3 things for him. A, creates a crisis frame. This is serious now. I need help. That unlocks donations from people who wouldn't normally give, or at least give at a greater level. B, creates a hero frame. We're fighting Eli with real lawyers. Even if no lawyer ever appears, the idea of it keeps donors engaged. He knows that. He knows how to prime these people. He's been doing it for years. C, creates a non-accountability exit. If no attorney appears, lawyers are expensive. I didn't raise enough. I decided to stay pro se. My lawyer said it wasn't worth it. All of those preserve ego and keep the money, right? So let's say he gets 3, 4, 5K. And then he says, what I said here, lawyers are expensive. I didn't raise enough. I decided to stay pro se. My lawyer said it wasn't worth it. He just made that money off of preying on the vulnerabilities of his audience. I mean, come on. Look, it's one thing for the people in that audience to not like me, right? It's another thing to be taken advantage of. Come on. You've seen this movie before, and yes, this is a very common creator litigation monetization move. A lot of creators do this. He's one of them. It is what it is. 4, why he is unlikely to actually retain counsel based on behavior, not speculation. Beyond cost, there are 3 structural reasons he likely won't. 1, attorneys shut down performance. He won't be able to perform on YouTube anymore. A retained attorney would almost certainly tell him, stop talking publicly about the case, stop mocking the opposing party, stop audience conditioning posts, stop speculative statements about court outcomes. That directly conflicts with his content model. Right. No attorney is going to take the case unless he completely backs off. Number 2, attorneys don't like clients who litigate on YouTube. And I'm not litigating on YouTube. I'm just sharing what happened. He's actually litigating. He's actually putting things out there, right? All I'm doing is correcting the record and updating people on what happened. Especially not clients who comment daily, antagonize the opposing party, crowdsource reactions, and contradict themselves on stream. If he has a GoFundMe, if he has any funds, it's not going to make him look good, right? It's not going to make him look good. Many attorneys, oh, and by the way, people that do donate to those funds, yeah, hang on a second. I had to respond to a text real quick. All right. So where do we leave off here? Many attorneys simply won't take that engagement without strict controls. So yeah, comment daily, antagonize the opposing party, crowdsource reactions, and contradict themselves on stream. Three, pro se keeps him in narrative control. Staying pro se lets him frame losses as persecution, frame wins as personal genius, and shift blame whenever needed. Counsel introduces an external authority he can't fully control. Number 5, what this means for me strategically. The court's safe move is to treat his lawyer talk as noise unless and until an attorney files a notice of appearance or the court docket changes. Everything else is content strategy on his side. And yeah, content strategy, monetization strategy, etc. Here's an updated correcting the record, now even tighter. Here's the best version given what you've added. He mentioned on his stream that he may hire an attorney. Whether he does or doesn't change my preparation. Until there's a notice of appearance in the docket, I'm proceeding exactly as required by the court. And I'll still proceed the same way even then. If you have any quotes, babe, or anyone has any final say in the chat, please get it in right now. We'll be going off the air in 5 minutes or less. Final synthesis. This is the important part. You added insight. Sorry, your added insight does not contradict the earlier probability assessment. It explains the behavior underneath it. So the refined conclusion is consulting a lawyer, possible, but also useful as audience theater. Fundraising around the idea, very likely. I think 90% chance he fundraises on this. Actually appearing through counsel in April, still moderate at best, staying pro se while monetizing the lawyer threat, highly consistent with past behavior. That would not surprise me. I look forward to seeing the attorney fund regarding the Eli case or whatever it is. And the best part, you don't have to call it out for it to be obvious. I know that. But I'm teaching a lesson, so I will call it out. And I know you don't want me calling it out. But I will. Because it's the truth of the matter. And when it happens, then we can all laugh at it, right? Judges, clerks, and experienced litigators recognize this pattern instantly, especially when it is paired with constant public commentary. You stay calm, you stay procedural, you wait for the docket. The contrast keeps working in my favor. And finally, babe, do you have a quote? Go ahead, get it in now. The delay hadn't caught up yet on the stream. Dawn has a quote. She'll be getting it in the chat now. Oh, she already has it in there. I'll get to it in a second. The big picture, why this hearing helps you going into April. So I told ChatGPT if this hearing hadn't happened until after April, the defendant may have had a better shot earlier, possibly, because that would be the first time us seeing the judge. That logic is solid. This hearing, the one we had yesterday, Friday, February 6, 2026, put a live credibility imprint in Judge Stacy's mind, showed who is procedurally constructive versus performative, removed the immediate spoliation sanctions cloud that the defendant wanted hanging over me, created a framework confidentiality agreement that makes me look reasonable and makes future disputes easier to police. And finally, and the defendant knows it, which is why his content immediately pivots into audience soothing plus re-anchoring to April. That hearing yesterday went a lot better than I thought it would. I didn't think it was going to go bad, but it was just really just easygoing. It was just like having a conversation with the judge, but with a little bit of legal speak that's required in the court, right? And for the most part, like I said, the defendant was pretty close to his best behavior. That doesn't mean his arguments were solid. He presented them in a calm way for the most part. But what he was presenting, had no merit. And he tried to push it a little bit. And, for the most part, Judge Stacy let him talk. She let us both talk. But he knows that performance is not going to work in the court. He knows everything he does between now and then will be filed with the court and can and will be used at that hearing. It's a dispositive hearing. That hearing is going to have a lot of evidence. This was not an evidentiary hearing. I believe they consider the MTD/anti-SLAPP is an evidentiary hearing. Let me double check through ChatGPT. I believe it is. I bet it says yes. Short answer, no. The MTD anti-SLAPP hearing is not an evidentiary hearing. It is a legal sufficiency hearing. The court asks, assuming the complaint's allegations are true, does the law allow this case to proceed? Focuses on pleadings, complaint plus attachments, 47 of them, in exhibits. Legal arguments, statutory standards, anti-SLAPP, burden shifting. What it is not: no witness testimony, no live evidence, no fact-finding, no credibility determinations. Judges do not weigh evidence at this stage. What can be referenced? The complaint and judicially noticeable materials. Limited exhibits only if allowed by statute or incorporated by reference. Prior rulings slash procedural history. The evidentiary materials I filed are to further assist that, what's been happening that's already been put in the complaints is currently happening. Now, there are additional defamatory statements that I filed since the Second Amendment complaint was filed. But there's plenty of defamation already in there. There's plenty of everything else. Malicious prosecution is there. I had a favorable outcome at the hearing where he tried to get a stalking order on me. Abuse of process with the process, the way he used the process server and then commercially exploited the footage, bringing the process server onto his show. I wonder what Judge Stacy's going to think about that. Also, intentional infliction of emotional distress, what this has put me through emotionally. At that point, I will be able to bring in witnesses to corroborate my emotional state. More than likely, once we get past the MTD/anti-SLAPP, okay, at that point, we're probably going to be doing depositions, possibly mediation and all that. Once we get past this MTD anti-SLAPP, at that point, we can depose people. And if we go to trial, if the case goes to trial, then we're going to have witnesses, and my Lady Dawn will be one of them. So I'm glad I looked that up because I thought actually that's evidentiary, but it is not. But you can actually bring in evidentiary materials to corroborate what's already going on as part of the credibility. And I've filed plenty of that for the anti-SLAPP already. All right. Don's quote, because I really got to get going. Don says, when court cases flood YouTube, real justice slows, smaller cases get buried, and creators' channels suffer in the noise. Very true. When court cases flood YouTube, real justice slows, smaller cases get buried, and creators' channels suffer in the noise. Good quotes, says ODN. Are you going to walk? No walk tonight, broski. Yeah, no walk, man. I knew this was going to go pretty long. I mean, we're at 2 hours and 9 minutes right now. I'm a little bit longer than I wanted to, but I got to run some errands with Don. We got to go to the supermarket and then a couple other errands, and then we're going to relax. I'll walk tomorrow, and then Don and I have the podcast to record tomorrow. But if you want to go live later tonight, ODN, and talk about what was said here, I've given a lot more information. Go back and check out the first part of the show because you're going to hear a lot about the Granny's watching stuff that some people were referring to in your chat. I did all the research, and you'll get that during the first 25 to 30 minutes of the replay. So that is that. No walk tonight, says respectfully, maturely, and professionally, Don. Thanks. Okay, thanks, Don, says ODN. All right, folks. We're ending this at 2 hours and 10 minutes. Have a good one. Take care. And as always, be good to each other.